Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be discussing about the very important case of RE HOLLAND, also known as Holland versus Commissioner for Her Majesty Revenue and Customs. It is very important that we look through the nitty-gritty of this case. Why? Because this case gives us more information as to what we mean by de facto directors, by shadow directors, and by de jure directors. By the time we looked at the cases that were discussed in this case, we look at cases like RE HOLLAND, we look at cases like Secretary of State for Trade and Industry versus Tijol. We look at cases like Canadian land. We look at other cases. By the time we look at these cases one after the other, when we discuss about shadow directors, de facto directors, as well as the jure directors, we would see there are so many things that this case will show us that the karma did not necessarily show us. So this particular case is going to be divided into different parts. This is the part 1 where I'll be talking about the facts. In the part 2, I'll be illustrating the judgment of the case. Part 3, the judgment as well. Part 4 and on like that till it finally ends. So let's talk about the fact for today. Now, according to the facts, Mr. and Mrs. Holland ran a business administering the business and tax affairs of contractors, especially those working in the IT sector, who did not want to go to the trouble of setting up and running their own company. In February 1999, a complicated corporate structure was established to run the business. Under this new structure, 42 trading companies were created, referred to in this proceedings as the composite companies. 2 further companies called Paycheck Directors Limited and Paycheck Secretary Limited were created to act respectively as the sole director and the secretary of each composite company. Now, let me explain to you what happened in layman terms. This is it. Mr. Holland and Mrs. Holland, they were directors of Paycheck. Now, you see, Mr. Holland looked at the whole society and said people are usually very busy, carrying on business, doing a lot of things. How is it that we can help them not only start up companies that can run their business better, but also help them when it comes to the tax affairs of their companies in such a way that they don't even need to be concerned with starting up the company themselves. Neither do they need to be concerned with the tax affairs of their company. We will be the ones concerned when it comes to that. Do you understand what I'm saying? So let me use it in more layman's terms. If you look at certain aspects of business, you have carpentry, you have plumbing, you have this, you have that. And those businesses are usually done by people who are most times illiterate, who do not know what it is like to start a company. When they say tax, when they start hearing money for tax, they be like, hey, what is this? Do you understand? Those are the kind of people that Mr. Holland said, you know what? I will start up a company for you. I would help you as well. Everything that has to do with the running of the company and all that. But Mr. Holland wasn't the one that was doing it. You should know that. Mr. Holland, through his company, that's the company that he is a director, both Paycheck Directors and Paycheck Secretaries Services, the both of them, they decided to start up 42 companies. And those 42 companies in the course of this particular case will be referred to as composite companies. Do you understand? Now, you already know the reason he set it up, because he wanted to help those people with, the whole struggles of starting up a company as well as their tax affairs. We understand that. And then we also understand that he wasn't actually the one in law that started the company. It was Paycheck Directors and Paycheck Secretarial Services that started up the companies. We have Paycheck Director as the director of those 42 companies. Each of those 42 companies, Paycheck Director is the sole director on each of those 42 companies' board. And we also have Paycheck Secretarial Services that is also the sole secretary on each of those boards. To make you understand better, If you are in Nigeria, you know that there's something called First Bank. First Bank Nigeria PLC is the bank that we know. Do you understand? The normal banking transaction we have is with First Bank. But that does not mean that First Bank does not have subsidiaries. First Bank has First Bank Insurance, First Bank Microfinance. These banks are separate legal entity. That's the insurance one, the one of microfinance. They are separate legal entity from First Bank PLC itself. But that does not mean that First Bank PLC cannot be a director in First Bank Insurance. Do you understand? So if any of the directors in First Bank PLC act for First Bank PLC on the board of First Bank Insurance, he is not acting. So if you have Ibukun Awoshika, who is the managing director of First Bank, if she sits on the board of First Bank Insurance representing First Bank PLC, then that is a different thing, because in that meeting she is not Ibukun Awoshika, she is First Bank. First Bank is a legal person, but we need to appreciate that no matter how much the law confers the toga of personality on First Bank PLC, First Bank cannot walk and talk except with a person. So Ibukun Awoshika becomes that person that has to represent First Bank PLC on the board of First Bank Insurance. Do you understand? That's the same way, in as much as we recognize the fact that paycheck director is a legal person in law, we also have to appreciate the fact that paycheck directors cannot speak, cannot talk, cannot walk, and paycheck directors need somebody to act. Mr. Holland is acting for paycheck directors on the board of those 42 companies. So now that we understand a little bit of the fact, another thing we need to know is, when you're going into a business, you ask yourself, what is my gain in this business? Therefore, we need to ask Mr. and Mrs. Holland, if you are opening 42 companies, running the tax affairs for those people, what do you gain? Let us move on. Mr. and Mrs. Holland were the directors of Paycheck Directors and Paycheck Secretarial Services and owned each company via another company. The business model involved the composite companies contracting out the services of to their clients. The contractors became both employees and non-voting shareholders of the composite company. The aim of the structure was to seek to ensure that the annual taxable profit of each composite company did not exceed £300,000 in order to get the benefit of the small companies rate of corporation tax. Do you see? Why did he do it? He did it because when each of those companies are set up for those people, so let us say we have a carpenter who doesn't understand English, who doesn't want to go through the whole rigors of creating a company. If they help him create a company and then they pay him dividend and every other thing, on a normal day, if they were supposed to pay tax of 10%, because there's a particular law that says for small companies whose profits do not exceed £300,000, you will pay 1%. He then looked at it and said, wow, there is money here. If I can do this in 42 places, instead of paying 10% in 42 places, I pay 1% in 42 places. It means inadvertently I would earn 9% of the profit of each company in 42 places. Do you understand the sense? He wanted to avert the tax. But for you to avert it and be smarter than the law and play into the hands of the law, you need to keep your profit below £300,000. How then can he do that? He can only do that if each of those 42 companies are treated as distinct and they are not treated as all together one entity. The next thing that he did was that those people that were working in those companies, he then decided to employ them into the company. On the normal day, they are the owners of the company, but he did not give them voting shares. He gave them non-voting shares. That's number one. And he was paying dividends on those shares. Number two, he made them employees in such a way that he was paying them salary. But don't forget that their business, the business of that contractor, if he's a carpenter for business one, His business is the main essence of that particular company. Okay, let's go to business 2, plumbing. Let's go to business 3, shoemaker. Let's go to business 4, this. Let's go to business 5 until he got to business 42. Do you understand? So each of the profits that they were getting, he divided it into 4 places. The first place, he paid them dividends. The second place, he paid them salary. The third place, he put the money aside for the small tax that he was supposed to pay to the government. And then the last one was his own profits. Did you see how he was trying to outsmart? If he had done it for just one company, it wouldn't make so much sense for you to go through the whole stress for just that little. That is why he opened 42 companies. But then the law outsmarted him at some point. But before we get to that, the fact says that from the income the composite company received from the contractor's clients, they paid a salary to each employee and shareholder, and also declared dividend to each employee / shareholder after making provision for the payment of the corporate tax at the small company's rate. Now, dividends were paid regularly on the basis of the timesheet submitted by the shareholders' employee for the work they perform as contractors. Paycheck Services, that is the secretary of each of those 42 companies, used a software program that calculated the dividend due and generated a document purporting to be the minutes of directors' meeting of the relevant composite company. You should know that even though Mr. Holland was the sole director of Paycheck Directors, and Paycheck Directors was the sole director of each of those 42 companies, when Mr. Holland was to take a decision, he never took a decision independently. Every decision that he took was the decision of the minute of the directors meeting, in such a way that before he took the decision, he would get the minutes of the directors meeting. There is this question that, but there is no other director. You are the only person on that board, not representing yourself, representing Paycheck. So each of the time that you were in the directors meeting for those 42 companies, each of the 42 companies, you were in fact acting as one person. Why then do you need minutes? You see, it is important to use minute of those meetings, because if you are taking certain steps independently, probably the judgment in this case would have been different. But for the fact that number one, he had the minutes of each of the meeting. Number two, which is also very, very important, the program generated onto the minutes a copy of Mr. Holland's signature authorizing the dividend, which appeared the words for and on behalf of Paycheck Directors Limited Services. So not only was there minute of meeting for everything that Mr. Holland did as director of Paycheck, who is the corporate director of those 42 composite company, Mr. Holland also made sure that for every time that he had to append his signature, he made sure that such signature was for and on behalf. He always wrote it there, for and on behalf of Paycheck Directors Services Limited. Now, Paycheck Services received a fee for its administrative services. No allegation was made that this structure was a sham, and there was never any pleading of dishonesty against Mr. and Mrs. Holland. However, HMRC did challenge the structure. The structure failed because Mr. Holland was a settler of each of the voting share in each composite company, with the result that the composite companies were treated as associated. You see, I told you that the law caught up with Mr. Holland. He was trying to make sure that each of those 42 composite companies were not treated as one and the same. They were treated as different companies in such a way that for the purpose of tax, each of them will be small companies. And if you are looking at them as small companies, then their profit will fall below £300,000, which was a major criterion for you to be eligible for small profits. Do you understand? Now, because Mr. Holland was the sole settler of the one voting share in each of the company, the law caught up with him, and then all the 42 companies were treated as associated. And if you look at all the 42 companies collectively, if they are to be treated as associated, it means that their profit would be above the £300,000 margin. Therefore, they will no longer use that small company's tax. They will now use the normal one, which is quite high. Do you understand? Don't forget that he had already paid dividends. He had already paid salary for each of the 42. So each of the 42 companies did not have so much money left anymore. The resultant increased tax liability meant that the composite company were insolvent. The HMRC being the only creditor, which means that the HMRC was being owed at the end of the day. HMRC alleged that Mr. and Mrs. Holland were de facto directors of the insolvent companies and responsible under Section 212 for causing the payment of dividends to the company shareholders, in bracket contractors. Don't forget that those shareholders were non-voting shareholders, but they were still the contractors. They were the bane of the business because Mr. Holland set up the company for them. HMRC sought orders requiring Mr. and Mrs. Holland to pay amounts in excess of 13 million to compensate the insolvent companies. The High Court dismissed the claim against Mrs. Holland and that decision was not appealed. However, the High Court held that Mr. Holland was a de facto director of each composite company and so in principle answerable to HMRC's claim. The Court of Appeal unanimously allowed Mr. Howard's appeal and held that he was not a de facto director of the composite company. The High Court said he was a de facto director. The Court of Appeal said he was not a de facto director. What was the main argument? The main argument was that Mr. Holland was no longer at some point acting on behalf of the company. That's paycheck directors as the sole director of those 42 other companies. Mr. Holland has come out of the body. I need you to imagine a person coming out of a person. Do you understand? That when the board meeting was going on, the only legal director in that board meeting for each of those 42 composite company was paycheck directors. But they are alleging that Mr. Holland has come out of the body of paycheck. Mr. Holland was now sitting independently as a director. So which means there were two directors in that board meeting. There was paycheck director, although not physically represented, and then there was Mr. Holland. When you are referring to a de facto director, he need not have been appointed in accordance with law. Even where he has not been validly appointed, if he acts as though he were a director, the law will confine him with the toga of being a director. Now, in this case, that was exactly what they were arguing. They were saying that Mr. Holland has come out of the body of paycheck directors, and Mr. Holland was now a director sitting on that board. But Mr. Holland was saying, no, at every point, I never acted as a director. I always acted as the director representing the real director on this board, which is paycheck directors. I never at any point come out of paycheck directors. I was always at every point working as, paycheck directors. Do you understand? So we need to look at what did the House of Lords hold in this particular case. Did they say he was a de facto director? Did they say he was not? And if he was, what were the reasons? I need you to follow while I walk you through this case, because there are certain cases that we are going to look at. There are certain words that the judges use, and I need you to pay very apt attention. I will see you in my next class as I discuss the judgment of this case.